Opportunity to hear scholars, practitioners, and business leaders discuss the promises and the challenges that the Commission and others should consider in charting a new regulatory path forward for this industry in the United States. In today's roundtable, we'll spend some time considering where the boundaries lie between financial activity that should be regulated because it is intermediated by centralized entities, and financial activity that does not involve such intermediaries and thus may be outside the scope of the securities laws. We're fortunate to end our roundtable series as we began with Troy Paredes as our moderator. Thank you, Troy, for making a second appearance. And as with each of our previous roundtables, we have a fantastic group of panelists today to help us understand what it means for finance to be decentralized. Before I conclude, I would like to express my appreciation for the enthusiasm that all of you have shown for this series of roundtables and for your contributions through engagement with the task force and through conversations elsewhere with the ideas our panelists have articulated on this platform. I also want to express my appreciation to the amazing team of people from the task force and throughout this building who've put in countless hours to make these roundtables happen. Watching the effort that has gone into planning these events, and believe me, Commission processes for planning this sort of thing are as thorough as anything else done at the Commission, has more than once made me wonder whether sprint was quite the right term for this effort. I don't have time to thank everybody involved, but I do particularly want to thank my team, and especially Samira Yunus, Ileana Chiabano, Robert Tepley, and Landon Zinda. In closing, I would like to remind everyone that this event is being streamed live and is being covered by multiple media outlets. Accordingly, please be aware that all remarks by Commission officials, participants, and members of our audience will be on the record. In addition, please remember that the participants in today's roundtable speak on their own behalf and that their views do not necessarily reflect the views of the Commission, the Commissioners, or members of the Commission staff. We're now ready to begin with remarks from Chairman Atkins, followed by Commissioner Crenshaw, Commissioner Ueda, and Commissioner Peirce. Mr. Chairman.
Oh, great. Well, thank you very much, Richard, and good afternoon to all of you here in our auditorium and online as well. So it's a great pleasure to be with you all today. Let me begin by thanking Commissioner Peirce and the Crypto Task Force for their organizing of today's event, and Commissioner Crenshaw and Commissioner Ueda for their participation as well. Of course, I very much thank all of you here on the roundtable, for panelists, and our moderator, Troy Paredes, for Commissioner Paredes, for your voluntary contribution of time and talent to this mighty endeavor that we're undertaking. So today's roundtable is entitled DeFi and the American Spirit. This is, I think, an apt title because the American values of economic liberty, private property rights, and innovation are in the DNA of DeFi, or decentralized finance, and the movement of that. Blockchains, of course, are a very creative and potentially revolutionary innovation that have us rethinking evidence of ownership and transfer of intellectual and economic property rights. They are shared databases that enable the ownership of a type of digital property called crypto assets without reliance on an intermediary or central party. Instead, these peer-to-peer networks incorporate an economic mechanism to encourage participants to validate and maintain the database in accordance with the network's rules. These are free market systems where users pay demand-based fees to network participants to have their transactions included within a so-called block of data with finite storage capacity. The prior U.S. government administration discouraged Americans from participating in these market-based systems by asserting through lawsuits, speeches, regulation, and threatened regulatory action that participants and staking as a service providers may be engaged in securities transactions. I'm grateful to the Division of Corporation Finance staff for clarifying its view that voluntary participation in proof of work or proof of stake network as a miner or validator or staking as a service provider is not within the scope of the federal securities laws. As happy as I am over that step, this statement is not a duly promulgated rule with a force of law, so we cannot stop there. The Securities and Exchange Commission must adopt a regulation based on the authority that Congress has given us. Another core feature of blockchain technology is the ability of individuals to have self-custody of crypto assets in a personal digital wallet. The right to have self-custody of one's private property is a foundational American value that should not disappear when one logs on to the internet. I'm in favor of affording greater flexibility to market participants to self-custody crypto assets, especially where intermediation imposes unnecessary transaction costs or restricts the ability to engage in staking and other on-chain activities. Unfortunately, the prior administration undermined innovation in self-custodial digital wallets and other on-chain technologies by asserting through regulatory actions that the developers of such software may be conducting brokerage activity. Engineers should not be subject to the federal securities laws solely for publishing this type of software code. As one court put it, it would be irrational to hold the developer of a self-driving car liable, and here quoting from the court's decision, quote, for a third party's use of the car to commit a traffic violation or rob a bank. In those circumstances, one would not sue the car company for facilitating the wrongdoing. They would sue the individual who committed the wrong. And here just recently, the Supreme Court in a case regarding firearms underlined that particular sentiment. Many entrepreneurs are developing software applications that are designed to function without administration by any operator. The idea of self-executing software code that's accessible to everyone but controlled by no one, and that enables private peer-to-peer transactions may sound like science fiction. But blockchain technology makes possible an entirely new class of software that can perform these functions without an intermediary. I do not believe that we should allow a century-old regulatory framework to stifle innovation with technologies that could upend and, most importantly, improve and advance our current traditional intermediated model. We should not automatically fear the future. These on-chain self-executing software systems have proven to be resilient in the face of crises. While centralized platforms wavered and failed under recent stresses, many on-chain systems continue to operate as designed, pursuant to open source code. Most current securities rules and regulations are premised on the regulation of issuers and intermediaries, such as broker-dealers, investment advisors, exchanges, and clearing agencies. The drafters of these rules and regulations likely did not contemplate that self-executing software code might displace such issuers and intermediaries. I've asked the Commission staff to explore whether further guidance or rulemaking may be helpful for enabling registrants to transact with these software systems in compliance with applicable law. I'm also excited about the use of on-chain software systems by issuers and intermediaries to eliminate economic frictions, increase capital efficiency, enable new types of financial products, and enhance liquidity. Current securities regulations already contemplate the use of new technologies by issuers and intermediaries, but I've asked the staff to go further and to consider whether amendments to the Commission's rules and regulations would be better suited to provide needed accommodation for issuers and intermediaries to seek to administer on-chain financial systems. So while the Commission and its staff work to propose fit-for-purpose rules of the road for on-chain financial markets, I've directed the staff to consider a conditional exemptive relief framework, or let's call it an innovation exemption, that would expeditiously allow registrants and non-registrants to bring on-chain products and services to market. An innovation exemption could help fulfill President Trump's vision to make America the, quote, crypto capital of the planet, unquote, by encouraging developers, entrepreneurs, and other firms that are willing to comply with certain conditions to innovate with on-chain technologies in the United States. So with that, thank you all very much for your attention, and thanks again to the participants for what I anticipate to be a really good give and take on the panel. And Troy, keep them in line and get all the best ideas out. But thank you all very much, and have a good afternoon.
Good afternoon. As we begin the final event of this Crypto Task Force series, I think this is a good opportunity to reflect on what has come out of these roundtables and where the task force and the Commission are going from here. These roundtables have highlighted that crypto is far from a monolith. We have heard a markedly diverse set of viewpoints from many different segments of the industry. We have heard, for example, from many non-SEC registered entities with varying views on whether they or their products should be required to register and be subject to SEC jurisdiction. I expect that this will be a key theme of today's DeFi panel. Back in November of 2021, I wrote an article detailing my views on the opportunities and challenges of DeFi, which I believe require industry and regulatory collaboration to develop compliant solutions. The issues I raised in that article related to market structure, transparency, and retail investor protection, among others, and still remain questions today. So I look forward to hearing the panelists' views on how we should approach these challenges. Beyond issues related to registration and jurisdictional lines, other roundtables have focused on current SEC registrants who want to continue operating under SEC oversight, but with altered regulatory requirements tailored to new types of products and technologies. In addition to these varied and sometimes competing regulatory views, we've heard different opinions on the technologies underlying digital asset products and services. We've heard panelists highlight advantages or disadvantages of particular technologies and give differing predictions on their capabilities to function effectively as part of a large, complex securities market. In sum, these roundtables have given us a lot to grapple with, to say the least. While the series was billed as a spring sprint towards crypto clarity, I am unsure whether we've identified much can be simply or quickly clarified. When it comes to crypto, it does not appear to me that the SEC is facing problems with ready or easy solutions. What we are facing is heightened expectations of rolling out major changes quickly to pave the way for crypto expansion into the capital markets. With issues this complex and stakes this high, it's better to do it right than fast. We need to grapple with the tough questions through the legally sanctioned process of formal rulemaking, as Chairman Atkins mentioned, with the full opportunity for notice and comment and public interest findings. I look forward to engaging with my fellow commissioners, the staff, and the public on what I hope will be a thoughtful and mission-driven rulemaking process for this space. Thank you to all for the roundtables you put on, all the work, and thank you all for being here today. Appreciate it.
Well, good afternoon, and thank you to the panelists and all the attendees today for the Commission's 5th roundtable organized by the Crypto Task Force entitled DeFi and the American Spirit. Reflecting on the American spirit brings to mind the expedition of Meriwether Lewis and William Clark about 220 years ago On May 14, 1804, Lewis and Clark set out to explore the new Louisiana Territory, purchased the prior year by President Thomas Jefferson. The size of the United States had doubled overnight, but there were no reliable maps or established routes through the new land. Despite this daunting challenge, Lewis and Clark entered the wilderness to carry out their mission. While not nearly as fraught with personal danger, the Commission is similarly navigating through challenging new terrain and plunging into the regulatory wilderness under the leadership of Commissioner Peirce and the Crypto Task Force. While the Commission's tools, we don't use wagons and rope and pickaxes, but instead are things such as roundtables, public consultation, and economic analysis may be different. I am confident that our expedition can succeed in updating our rulebook to open up new opportunities for American investors and businesses. The SEC's treatment of decentralized finance and other emerging technologies over the past 4 years was not conducive to regulatory transparency and discouraged entrepreneurs and those developing DeFi from engaging with the Commission. However, that approach has recently changed under the Crypto Task Force, which is charged with coordinating the Commission's efforts to find answers to many pressing questions. Thus far, they have changed the SEC's posture on crypto, embraced difficult regulatory questions, and promoted transparency by engaging with market participants, driving innovation and change. This SEC is committed to high-quality regulation. High-quality regulation takes time, and administrative processes matter. For those who are involved in the development of DeFi, please be patient and work with the Commission and its staff towards achieving the best possible outcome. Although I am uncertain as to what the perfect regulation may look like, the path towards it begins with seeking input from the public. This journey towards regulatory clarity will likely be frustrating and may move in fits and starts. However, by learning from DeFi innovators and advocates, the Commission has a better chance at regulating securities transactions involving DeFi and protecting American investors who utilize decentralized financial services and products. Today's participants will provide knowledge and insight about DeFi's development and the existing regulatory barriers preventing growth. Such contributions will help the Commission attempt to strike the proper balance between its role as a regulator and its mandate to foster competition, efficiency, and capital formation. In DeFi, there is a landscape of new opportunities. People can transact directly with each other without relying on banks or other centralized intermediaries. The Commission should not refrain from engaging in oversight of novel areas simply because it involves thinking outside the existing framework. The legacy regulatory regime under the federal securities laws presupposes the existence and necessity of numerous intermediaries. I look forward to hearing from today's panelists as to whether such presumptions remain necessary. For example, in what types of situations do DeFi systems and smart contracts potentially eliminate the need for a financial intermediary, and how? In what situations should DeFi systems be deemed to fall outside the scope of the securities laws? What key safeguards are necessary when the securities laws apply to these arrangements? Lewis and Clark's journey lasted over 2 years and carved out an important path to facilitate westward expansion. In doing so, they provided a valuable contribution to American progress. Today's roundtable reflects the SEC's commitment to continued progress and its willingness to consider the roles of emerging technologies. As the Commission continues to move through the regulatory wilderness, it should remain true to its mission of protecting investors, maintaining fair, orderly, and efficient markets, and facilitating capital formation in its efforts to respond to market innovation. So thank you very much, and I look forward to the conversation.
Okay, we're almost there. We didn't bring you guys here to listen to us, but I do want to welcome everyone who's watching, and I want to thank Chairman Atkins, Commissioner Crenshaw, and Commissioner Ueda for your remarks. And of course, I'm excited to be here for our final roundtable, DeFi in the American Spirit. Thank you, Troy, for coming back and joining us. We thought you did a fantastic job the first time around, so it's great to have you back with us again. We have high expectations based on your last performance. And thank you to all the panelists for taking the time to join us today. Over the past 4 months, the task force has held roundtables on security, status, trading, tokenization, and custody. These roundtables have provided invaluable input for the commission and the task force and the rest of the staff here. It's informed our views and has improved our efforts and will continue to do so. The task force has hit the ground running in this sprint, as you've heard, but I do think that it's more likely to lead to a marathon toward regulatory clarity. I hope that it doesn't take as long as Lewis and Clark did with their expedition. I don't want to be doing this for 2 years, but I hope that we can make some progress, and I know that all of you will help us in making that progress. So you may be asking, what business does the SEC have in talking about regulating DeFi? Absolutely none is a reasonable answer, so maybe we should just stop now and go home. But as you know, it's Washington, and so we can't do things that fast. We have to, it's not that simple. Even getting to know regulation requires some talking, and that's what we're going to do today. What is DeFi? Bitcoin is decentralized finance, but it may not be what first comes to mind when you think about that topic. If we trust Google, it says that DeFi is a blockchain-based financial system that aims to replace traditional financial institutions with peer-to-peer transactions and smart contracts. It brings to mind decentralized networks which enable people to trade tokens and derivatives, engage in lending, or participate in prediction markets. Although sometimes referred to as DeFi platforms, DeFi is not a place people go to access services that someone else provides and controls. It's software code that people use to engage in the activity of transacting without a centralized intermediary. So to channel one of today's panelists, I do not go to a decentralized exchange, I make a decentralized exchange. Thank you, Peter, for that. DeFi defies our traditional permissioned world of intermediaries. It enables a person to engage with her peers through a protocol that is open to everybody on the same transparent terms. No need to get consent from any centralized gatekeeper. At its core, DeFi, which blockchain technology enables, is about the freedom to transact with your peers without permission, interference, or intermediation. And that is why DeFi resonates so deeply with the American spirit. Also resonant with the American spirit is the ability of people to publish written material without permission. Code is protected speech. Because the First Amendment protects someone who writes a DeFi software protocol and publishes it, the SEC has no authority to demand pre-publication approval rights, even for code that could be used to exchange securities. The SEC must not infringe on First Amendment rights by regulating someone who merely publishes code on the basis that others use that code to carry out activity that the SEC has traditionally regulated. If somebody else subsequently violates the law using the software protocol, the user, not the developer of the software, should face the music. But sometimes the writer of a protocol used to exchange securities does more than merely publish it. She might also operate, administer, or maintain a platform through which the code can be accessed and that takes custody of client assets or makes execution decisions for clients. In this and other instances, the coder or her platform might be subject to regulation for that conduct. If that conduct relates to securities, the SEC might have a role to play. I think it might be helpful to think about this in context of an enforcement case that the Commission brought 7 years ago, and that was its case against Zachary Coburn. That was a settled case, so we don't have the advantage of a court having wrestled with these facts, and the order is actually pretty sparse in detail. But Coburn developed the code for Ether Delta in exchange for ERC-20 tokens. And under the Exchange Act, the SEC charged Coburn with causing Ether Delta's violation of the requirement to register as a securities exchange per Section 5 of the Exchange Act. Although, again, the details are pretty sketched out pretty lightly in that settlement order. I think there are some facts that could help spur discussion on which types of activities the SEC should Coburn was the only person with the ability to alter the Ether Delta smart contract, as he was the only person with access to the private key for the administrator account, which could be used to change the permissible fees for transacting using Ether Delta, or the address to which, of the account to which those fees were then directed. The order book sat on a centralized server that was maintained by Ether Delta, rather than on the Ethereum blockchain itself. So maybe some food for conversation at the panel today. Centralized entities that use DeFi protocols that someone else wrote to serve clients don't get a regulatory pass, of course. They can use that tool as much as they can use other kinds of tools. And centralized entities can't avoid regulation simply by rolling out the decentralized label. There's such a thing as DINO, decentralized in name only. With centralized entities, of course, comes the potential for fraud, conflicts of interest, principal agent problems, information asymmetries, and other issues that are common in traditional finance. And so those are the issues actually that DeFi was designed to address. But if you are dealing with centralized entities, that might be where the SEC's efforts are best spent, protecting investors, not from their own use of open source software code to engage in transactions with their peers. We also don't need to protect them from writers of code, but from providers of financial services. I hope that today's discussion will help us to ensure that SEC regulation is able to reach activities and entities properly within its ambit, regardless of what label they bear, without prohibiting the exercise of individuals' rights to publish code and interact with that code. So now I'll hand it off to Troy. I'm looking forward to the conversation. Thank you.
Thank you, Commissioner Peirce, and everybody in the task force for the chance to be back and moderate the last of the roundtables. Very much looking forward to the discussion. Before we jump into the substance, let me walk through a few of the game plan points. This is as much for the panelists as for all of you to know how this is going to proceed. So the first thing I will say is that I'll be calling on people, but so that the first three folks aren't caught off guard. They don't know who they are yet. I'll tell you who you are. It's going to be Rebecca, and then Eric, and then Michael Mosier. And then I'd ask that you keep your responses, particularly this first go around, to no more than 2 or 3 minutes, so we have time to get everybody's views on the table, and then we can really get into the discussion. When responding, your bios are on the task force webpage, and it's an incredibly impressive group of individuals. So no need to give your bio, but you could just say your name and say your affiliation and leave it at that, and folks can take a look at the webpage to get more of the particulars on your impressive backgrounds. I'd ask next that you keep it as much as you can, even if it's more than you're otherwise willing to, as much as you can. Engage and interactive with one another. I would ask that you get my attention if you want to chime in. I'll keep a queue, try to keep it moving. If there are things I hear that folks are talking about similar points, I may jump around a little bit and call somebody to see if they want to weigh in. But if you just get my attention, I'll keep the queue, and we can make sure that folks have a chance to weigh in, because the more engaging it is, I think the more productive it will be for the commission. If I interrupt, I apologize in advance for being rude, but if I interrupt, it's simply to try to keep it moving so we can make sure that everybody has an opportunity. Hopefully I don't need to do that, but just fair notice on the chance that I do. One thing I think would be very, very helpful is if you're using a particular term of art, jargon, what have you, that can be useful because it can be an efficient way to move the discussion along. At the same time, not everybody has the same understanding, or people may use a word a different way or use the same word differently, what have you. So if there's a key term you're using, take the 10 seconds to find your terms. That way you can just help make sure that any points of clarification can be highlighted at the outset. We'll go for about an hour and a half until just shy of 3 p.m. Eastern time. We'll then have a break. And then after the break, there will be audience questions. I'll come to this in a minute that folks can submit. I'll fold those in to discussion, piggybacking on a number of the things that came out in this particular session, and have a good discussion after the break as well. To that point, questions are encouraged. There's a table, as I understand it, in the entrance before you came into the auditorium. I think you can find that. If you want to submit a question, just write down your question. You can find somebody who's wearing a name tag that says, I'm part of the crypto task force here at the SEC. Give it to them. And if you're joining online today, you can submit questions through the Commission's website at crypto@sec.gov. And just note roundtable question in the subject line, so folks who are monitoring that know what you're reaching out on. And when all is said and done today, there will probably be some disagreement. Hopefully there'll be some agreement, but I think it will be most productive if there's a good, lively, engaging conversation. Going back to what Commissioner Peirce said in her remarks, there's a heck of a lot to think through. And I don't think we could have a better group of panelists to help the commission do so. So, with all of that out of the way, Rebecca. So if you could start us off, set the stage, if you will. Maybe the biggest question of all, given the the roundtable today, and that is, how would you describe DeFi, and what are its distinctive features as compared to TradFi? And along those lines, is it too amorphous to define? Should we be okay with a more principles-based approach? Should we have something which is very nitty-gritty, technically technological in nature? And how does that inform, just as a general matter, the mindset that you think one ought to bring when trying to figure out DeFi, what it is, what its opportunities are, perhaps what some of the risks are, and what those implications then are in terms of thinking about what the appropriate regulatory framework ought to be?
Thanks so much, Troy. Thanks to the Commission for having me today and for convening this roundtable. DeFi stands for Decentralized Finance. I'll start at a very high level, the 30,000-foot view, and then try to get a little more into the weeds as I go in my short period of time. But none of industry regulators or policymakers, I think, have been able to come to a consensus on how to define DeFi. I typically define DeFi as a blockchain-based open software system that allows users to engage in economic transactions in a self-directed and entirely self-custodial manner without the need for traditional intermediaries. There are other people who, and a lot of regulators have defined it as simply a blockchain-based system that allows financial services. That is very broad and probably would encompass many of what even banks are trying to build today in terms of DeFi. In terms of their work with crypto assets. And some people have gotten very, very technical, as you suggested, Troy, to get into the details of, how the technology itself works, how smart contracts, which are pieces of self-executing code work, and the like. I think we also need to think about what is decentralization as we think about DeFi. Decentralization is a philosophy that generally espouses movement away from power, authority, or control being centralized with one entity or one actor, and moving towards a disintermediation or a dislocation of both actors, jurisdictions, and other dispersion of the concept of power and control. In terms of thinking about regulating DeFi today, and I'm sure we're going to get much more into the details about this, but I don't think it's actually necessary to either define decentralization or DeFi in order to determine whether a particular actor needs to be regulated. I think, as we heard in many of the opening statements, just publishing code alone is not regulatable via something like the Securities and Exchange Commission. But when we are thinking about what types of activities people are engaged in, we can understand where there may be an intersection of the law and technology, or the law and certain types of technological functions. I think algorithmic trading is a great corollary to think about it. Because in theory, the algorithm that is making asset management or investment decisions could function on its own, but you have the investment advisors register even when they're using these algorithms and codes, because they can impose their judgment, they can override the algorithm when there are other types of concerns around it, and they do still, even when using code, take on certain types of control or authority activities that may require and does require in many instances regulation. So when you think about a decentralized exchange that is operating autonomously, much like the Uniswap code does, that doesn't seem to require, as of today, regulation of the people who built the code. But the question then becomes, well, what if you have independent third parties building Uniswap pools with tokenized securities, and who is responsible and for what in that type of activity? I think the other complicated, this is my last point, the other complicated piece with DeFi is a lot of the activities don't look like anything we are used to in traditional finance. So questions of holding keys to a multi-signature wallet that can pause a DeFi protocol in the case of emergency does not look anything necessarily like pulling the circuit breakers on the New York Stock Exchange or something like that. So I think moving away from just the definition of what we think of as DeFi or decentralization and really thinking about activities will move us forward in thinking about how we could regulate the space, if at all.
And just a real quick, and there'll be more opportunity, Rebecca, for you to pick up this point. But in addition to that distinction, as you were describing, we can say code on the one hand versus activities on the other, where does risk fit in is also part of the consideration, not only thinking about what are the activities, but what are the risks, and are those the kinds of risks for which a regulator should be playing a role or not? Is that part of it as well?
Great question. I think that there are three central risks that, no pun intended, that come from DeFi. One is cyber risk. I think when you really think about how these DeFi systems are built out, cyber is the most important because it is code and it is functioning autonomously, in at least for certain types of DeFi protocols. I think then there's also something called system management risk. It is there an intermediary, or is there somebody who has some form of control? Is that properly disclosed? And are they properly, I think, as we think about for Web 2 types of software platforms, protecting against certain vulnerabilities and the like. And then I think that there is potentially illicit finance risk, but the source of that comes from usage and other actors engaging in the space. And there are, I'm sure we'll get to this later, but there are ways to mitigate against that. But it doesn't look, it goes back to what I was saying before, something like holding the keys to a multi-signature wallet doesn't look the same as, the other types of traditional activities. One thing I wanted to follow up on was your question of what are the hallmarks of DeFi? I'm sure other panelists will get into that, but I think just to do it quickly, non-custodial, I think is, or self-custodial is a non-negotiable when you're thinking about DeFi. I would also say open source so that everything is transparent and openly available. I think one of the much different than how DeFi is portrayed. It is not some shadow system that's being built in the dark. I think DeFi is open, transparent, and really trying to be built in the light and autonomous as well so that it can function without intermediaries.
Great. So I'm going to go a little bit out of my initial order because Peter's getting my attention. So I'm going to go ahead and have Peter jump in here, and then I'll come back to Eric.
Thanks, Troy. I just wanted to make a brief interjection on the question of risk and how we use it to define regulated entities. There's a very catchy phrase, same risk, same regulation, that often has a lot of wisdom to teach us. I think that, and Commissioner Peirce teed this up with a lot of discussion about First Amendment rights in this context. That's a utilitarian calculus that we see out in the world, that there are these harms that represent certain things that could be addressed through public policy initiatives, and that we could ultimately, through a consequentialist view of the world, improve the social utility of these markets, reduce investor harms. That kind of consequentialist calculation is almost always the right calculation to make, except where certain long-held American values are at stake with making that calculation. So I just briefly hearken to Ronald Dworkin, a personal hero of mine, who identified certain rights as trumps. That phrase unfortunately means something different now that we have a President Trump. But there's this notion that yes, we're always going to want to try and craft our regulation or our way that we address public dilemmas with an eye towards maximizing the good. But at a certain point, even if it's the socially beneficial outcome, there are certain areas we don't tread in this country. At a certain point, a right, like my right to publish code, trumps the risk that that code creates in the world. And so the risk created by perhaps a DeFi trading algorithm that allows people to engage in decentralized exchange, which is a verb, not a noun in this case, might be very similar to the risks that we see in centralized exchanges and might lead to similar bad outcomes for individuals in America. But even given that there might be some same risk, same regulation questions at play here, we would not put a prior restraint on an American's ability to publish that software. And there's more we can discuss later, I'm sure, about past case law with the SEC and the First Amendment in, say,